trying to provide SCOTUS with some fuel for the fire that they will hopefully set on anti-2A laws across the country. This one comes in the form of an amicus brief that CRPA filed last week in Antonyuk v. James. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we have more argumentation for the Supreme Court. This time it comes in the form of an amicus brief in the Antonyuk v. James lawsuit that currently sits all the way at the top at the Supreme Court. To talk us through that today, we have brought back CRPA President Chuck Michel. Chuck, thanks for being with us today.
Always a pleasure, guys. Thanks for having me.
Yeah, absolutely. So, and guys, before we get into that, please be sure to like, share, and subscribe to these videos. It goes without saying at this point, but I gotta do it. It really helps the algorithms push this message out to as many people as possible. We're trying to educate as much as we can so that we can continue the ball rolling with the Second Amendment movement here in California and the United States. So, Chuck, can you walk us through up to this point where we're at filing this amicus brief with the Antonyuk lawsuit, just as far as its argumentation and its path to the Supreme Court?
Well, remember the big picture here. There's been several different types of cases that have been litigated post-Bruin. To oversimplify, there's hardware cases, meaning like in California, the Unsafe Handgun Act, or the semi-auto ban, or the 10-plus round magazine capacity ban. Those are kind of hardware cases. Then there's prohibited people cases. And so we've got questions about whether or not marijuana users or nonviolent felons or other nonviolent classifications, even some misdemeanors, whether they can be banned to have their Second Amendment rights stripped away from them as a class. And that was Rahimi. And then there's places where they want to ban guns in certain places. And remember, in California, for example, since 1923, if you had a concealed carry permit, you could carry pretty much anywhere. So in response to Bruin and Rahimi, the anti-gun owner states, the blue states, prodded by the Bloomberg lawyer group, who basically is ghostwriting a lot of this stuff, guiding these anti-gun owner states on how to mess with the Second Amendment, have pushed hardware cases, they've pushed prohibited people cases, and they've pushed prohibited places cases. And so they're now trying to make, the Bruin court said you could prohibit guns in certain sensitive places. They have to be truly sensitive, like a courthouse behind a metal detector or something like that, not just any place where the anti-gun folks, politicians, want to ban the possession of firearms. But that's what New York did in Antonyuk, and that's what California did, and we challenged in the CRPA's May case. So these sensitive places cases are working their way through the courts. The first one that got to the Supreme Court was Antonyuk, and it went up and down a couple of times because there's another trend that's going on in the Supreme Court, which is they don't like to take cases that are on an interlocutory appeal. In other words, they're up on a preliminary injunction. And unfortunately, that's the posture with Antonyuk. It's not a final judgment yet. But the Supreme Court has telegraphed that they're very interested in not letting the Second Circuit get away with the shenanigans that court and the Ninth Circuit have been playing to try and water down Bruin and the Bruin decision and not comply with the mandates that the Supreme Court set out in that ruling. So in New York, they banned possession of firearms, even with a CCW, even with a license to carry, in a lot of places like the subway and parking lots and parks. And, it's just, they want to ban guns in as many places. They want to ban as many kinds of guns from as many kinds of people from as many kinds of places as they can possibly get away with constitutionally. So they're pushing the envelope. And that's what the Antonyuk case was about. So the Second Circuit has already been basically warned by the Supreme Court. So now we're back there again. And CRPA and the Second Amendment Law Center are working together along with a number of other groups. You have to play on a national field now. You can't just play in the California courts because it's a national right. It's a constitutional right that applies all across the state. So if you get bad precedent in one jurisdiction, it can it can hurt you in California or any other jurisdiction. Likewise, if you get good precedent, it helps.
Well, I guess that would be the interest of California, or at least an organization like CRPA, in discussing this. And you got to imagine that there's some interest with the Supreme Court justices as well, having gone into gone into sensitive places a little bit in the Bruin decision, even though it's up on an interlocutory appeal. Perhaps they're saying themselves, okay, this is an opportunity for us to seal this one up, or at least that's what we would hope for, right? But let's talk about the interest of Californians here, because we do have the amicus brief filed by CRPA. Jacob, if you could actually pull it up on the screen, there's a quote here that I wanted to discuss with you. It goes like this. Thus, the question presented here really is this: did the court mean what it said in Bruin? And if it did, will the court allow the very same state that nullified the right to carry through its unconstitutional good cause requirements to achieve the same results through other equally suspect methods? It is unfortunate things have come to this. In a healthy court system, the court's intervention would not be needed again so soon after Bruin was decided to vindicate the very right it recognized in that case. To be sure, this defiance is not an issue everywhere. In most states, the Second Amendment right to carry a firearm for self-defense was well respected even before the court mandated that the remaining states end their unconstitutional carry regimes. Bruin should have settled at least that issue definitively, and when applied in good faith, it did. American history teaches, however, that when a state and local government are forced to comply with Supreme Court rulings they disfavor, provincial defiance must be promptly quashed before it becomes the sort of ingrained custom, habit, or practice that grew out of Plessy v. Ferguson, like the massive resistance that sprang up in response to the court's decision in Brown versus Board of Education. A new massive resistance has been declared in the states that should have changed their public carry practices in light of Bruin. This has been enabled in some courts, including the Second Circuit when it upheld most of New York's Bruin response law, in the Ninth Circuit when it upheld even the private property default rule that the Second Circuit had stricken, creating a circuit split. That was from Wolford v. Lopez. So here we are. I guess, here we are again. We're kind, yeah, kind of back in the state of Bruin. I guess my question here is, this is kind of a reinforcement kind of argument, or at least that's the way that I read it. What is the goal for supplemental argumentation like this in a case at the Supreme Court?
Well, to narrow the issues and then really nail it down, and also to point out to the Supreme Court, although they're well aware of it now, that there's these shenanigans being played by certain circuit courts that are hostile to private citizen gun ownership, where they're twisting the Bruin rationale, the Bruin methodology, into something that it was never intended to be, or that the Supreme Court never said it was, because they want to uphold gun control laws and give the government the authority to basically ban as many types of guns from as many people from as many places as possible. They don't want to strike down any gun control laws. So the importance of the Supreme Court decision is twofold. First, it's going to characterize, it's going to set straight what is truly a sensitive place where guns can be banned. And more importantly, perhaps, what historical analogs, what's the methodology? How do you apply the Bruin decision to a modern law to determine whether or not that modern law is constitutional or not? And this is where the courts have been playing games and twisting that methodology to suit their the ends that they want to accomplish.
Well, at least, yeah, our courts here in California, as well as New York, and you could also say Illinois for that matter, have definitely been playing games. Who hasn't necessarily seemed to be playing games in this respect, though, is the Supreme Court. I'm also curious, how favorable does this look to you, having the votes go the way that it did in Bruin, having all of those justices still sitting on the Supreme Court, while the Supreme Court is taking on this case? How do you see that playing out?
Well, remember, we don't know if they're going to take this case. We've asked them to take the case. They haven't granted cert yet. Remember, it takes 4 judges to grant cert, 5 judges to win a case. So the case that's ahead of it, so this becomes a procedural kind of a chessboard question, like which case is where in the process. So right now we still have Snopes and another case pending in the Supreme Court. They're having a conference on the 28th to decide whether or not to grant cert in those cases. And then the CRPA has the Crossroads to the Rest gun showcase up there. Uh, and in the past, we had Duncan, we had Rhodey, we had other cases up there. So um, the court may or may not have some kind of an approach in mind where they're going to review Snopes and then hold some of these other cases, maybe keep postponing them. This is all reading tea leaves. We don't know what cases the Supreme Court is really giving priority to, but we hope that, and we think that this case that's there now, Antonyuk, gives them a sort of there's a certain emotional problem with PR with an assault weapon case, although the court generally doesn't pay any attention to that, especially conservative justices. But a sensitive places case is probably going to be easier to set the methodology straight than like a full auto, a semi-auto ban case. So we're just trying to give them as many opportunities to select the type of case that the Supreme Court wants. And at the five, we think we have at least five, maybe six justices on our side. Uh, uh, but it has to be sort of a palatable, if you will, case to the Supreme Court's liking, not necessarily politically, but at least in terms of legal reasoning. The clearer it is, the more likely they are to take the case to use it as their next precedent on the Second Amendment.
Yeah, so it seems like what you're saying is if we could have any input as to how the terrain is laid out for the Supreme Court, whether or not they're going to take a case, creating a likely scenario where they can take a case and really solidify what they were trying to communicate in the Bruin decision, they're going to take the more favorable one over the less favorable one, and this seems like it could potentially be working out this way. The last conference that we saw from the Supreme Court, they offloaded a ton of lawsuits. They remanded a bunch back down. Some of these more high-profile Second Amendment cases were not in that batch, which means that they are going to continue and be looked at. I guess, what are your final thoughts for the Supreme Court and these conferences going forward, and what does the timeline potentially look like for you?
It's not going to be this session. There's not going to be a case accepted that gets decided by June. So that'll be into the the Supreme Court session that begins in October. But they could take it before then and then just schedule it for briefing and oral argument during the next Supreme Court session. But to try and predict which one they're going to take first and how fast it's going to move, everybody thought they knew. Everybody thought they could predict this, but no one's been able to accurately. So we don't know exactly what it is that the Supreme Court is looking for procedurally. Again, I mentioned, like a preliminary injunction before a final judgment. Supreme Court generally likes to take a case that's all the evidence has been presented, there's been a trial, there's a final judgment, not just a preliminary injunction, which didn't involve all that evidence and discovery and a trial. They want the whole body of the case packaged up and to decide on the entire record generally. So that's the only thing that we've kind of learned to accept from the Supreme Court, is that they don't want cases that are only halfway cooked.
To say the least, we do currently have a Supreme Court that seems to want to solidify the constitutionality of the Second Amendment and really uphold that for the American citizen. So a lot to look forward to here, not just the Antonyuk case, but also the Snope case and a couple others. We're going to continue following along as we always do. But Chuck, I know you're a busy guy. I just want to say thank you for coming on and sharing today.
Always got time for you, fellas. Appreciate you helping get the word out. And thank you, everybody who supports the CRPA and all these legal efforts that we're leading the charge in California on.
Absolutely, and much appreciated. And guys, if you like content like this, you like being able to know what's happening at the Supreme Court and in the state of California, please be sure to like, share, and subscribe to these videos. It's a great way for you to directly contribute to the litigative and legislative causes here in the state of California. Thanks again, guys. We'll see you on the next one.